Hello and welcome to my another video. This is Dilwar Hussain in front of you. In this video, I am going to discuss about preliminary part of Cr.P.C. That means introductory part of Criminal Procedure Code 1973. Regularly, I am uploading law relating videos because who are interested to appear in the upcoming Public Prosecutor Examination or অসমীয়াত ইয়াক চৰকাৰী অধিবক্তাৰ চাকৰি বুলি কোৱা হয়. So candidates who are interested to appear in the upcoming Public Prosecutor Examination of Assam going to be held 2023 or maybe 2024. Already advertisement is given by the government of Assam and application procedure is going on. If that examination is held within very short time, then such videos will be helpful for the viewers. So let's start the video. Preliminary parts of 1973, that means introductory part. Cr.P.C 1973, Criminal Procedure Code 1973 came into force 1st April 1974. Very important points. Remember this. Cr.P.C 1973 came into force 1st April 1974. Received President's assent on 25th January 1974. Rashtrapati অনুমোদন পায় 25th January 1974. Very important points. Total 37 chapters and 484 sections and 2 schedule. Very important. Frequently question is come from that points. How many schedules are in the present Cr.P.C? Answer is 2 schedules. And how many sections? 484 sections. And what are the chapters? 37 chapters. Next, added in entry number 2 of concurrent list. Cr.P.C is added in entry number 2 of concurrent list. First schedule, in the Cr.P.C there are 2 schedules which I mentioned already. 2 schedules. First schedule describes classification of offenses and second schedule describes different forms such as summons, warrant of arrest and charges. In the second schedule, total 56 number forms are available. How summon is to be issued or how charge is framed. These are the forms or format is given in the second schedule of the Cr.P.C. Cr.P.C is procedural in nature. Cr.P.C actually is procedural in nature. Old Cr.P.C, there were 46 chapters, 565 sections and 6 schedule in old Cr.P.C, but in the present Cr.P.C, 37 chapter, 484 sections and 2 schedules. If we compare with the old and new Cr.P.C, then new Cr.P.C is very comfortable because in there 484 sections available. Principle of natural justice. Principle of natural justice is very important, and here 3 maxims is mentioned. Nemo judex in causa sua. No one is just in his own case. This is the principle of natural justice. No one is just in his own cause. Second number maxim, odi ulterium partem. Odi ulterium partem. Let the other side be heard as poet. Let the other side be heard as poet. Very important natural justice for Cr.P.C. Number 3 maxim, stare decisis. Stare decisis means to stand by things decided. To stand by things decided. Now, I am going to discuss about the definitions sections of Cr.P.C is very important. Section 2 describes different definitions which are very important in the Cr.P.C and for the candidates of the Judiciary Preparation or PP examination, because from section 2, 2 or 3 questions may be asked, such like as police report and summon case and warrant case and victim. These are the very important definition sections of Cr.P.C. So let's start. Section 2 of Cr.P.C is definition. Here different clauses is there, such like as English alphabet A to Z. Students of kindergarten learns English alphabets such as A to Z. Here also in the definition clause, various definition is given from A to Z. Here we are discussing now. Clause A, section 2, subclause A bailable and non-bailable definition, which is defined or which is mentioned in the first schedule. In the first schedule, bailable and non-bailable, cognizable and non-cognizable, and section of Cr.P.C. and which court is tribal is described very clearly. Clause B defines search. Read with section 211 oblique 211 and 224 of chapter 17 of Cr.P.C. clearly states about search, and search is defined in section 2 subclause B. Thereafter C. 2 subclause C defines cognizable offense. What is cognizable offense and what is non-cognizable offense? About cognizable offense, section 2 subclause L also defines. So 2 subclause L also defines cognizable offense and non-cognizable offense. Section D, complaint. What is complaint? If any person orally or in written form files any complaint before the magistrate is known as complaint, but not a police report. Very important topics. Then clause E of section 2 defines High Court. F defines India. G defines inquiry. Inquiry by police or magistrate authorizes such person to inquiry or investigation. Section 2 subclause H defines investigation. I defines judicial proceeding. Judicial proceeding, how a magistrate can take an evidence after oath. Section J defines local jurisdiction. Section 2 subclause K defines metropolitan area, and read with section 8 of Cr.P.C. If any area or town consists with 1 million people or 10 lakh people, then state government has power to declare such area as metropolitan area. Metropolitan area is the area where 10 lakh population is there, and state government has power to declare such area as a metropolitan area. Metropolitan area defines in section 2 subclause K. Thereafter L, non-cognizable offense. Non-cognizable offense means police has no power to arrest without warrant, and cognizable offense defines section 2 subclause C. Cognizable offense means an offense in which police officer can arrest without warrant of magistrate. Section 2 subclause M defines notification. Thereafter N defines offense. 2 subclause N defines offense. Read with section 40 of IPC. Section 40 of Indian Penal Code also defines the term offense. Thereafter 2 subclause O defines officer in charge of a police station. 2 subclause P defines the term place. Place means house, building, tent, vehicle or vessel. Section 2 subclause Q defines pleader. Who are pleader? And after completion of LLB, a lawyer enrolls his name in the State Bar Council, and State Bar Council give him license to plead for another before any court or legal authority. Such person is known as pleader. Pleader is very essential in a case for trial purposes. So section 2 subclause Q defines the term pleader. Section 2 subclause R defines the term police report. Read with section 173 subclause 2 of Cr.P.C. After completion of investigation, police officer has to file a report to his concerned magistrate under section 173 subclause 2. Such report is known as police report and defines in section 2R. Thereafter section 2 subclause S defines the term police station, and thereafter section subclause T defines the term prescribed. 2 subclause U defines the term public prosecutor, and also who are public prosecutor and who can appoint the public prosecutor defines details in section 24 of Cr.P.C. Section 2 subclause V defines subdivision. In a district there are different parts, and such part is known as subdivision. Section 2 subclause W, very important, summon case, and summon case also discussed in section 251 to section 259 of Cr.P.C. What are the summon case and what are the warrant case? Section 2WA defines the term victim. Who are victim? And the term victim is added in the Cr.P.C. by the Cr.P.C. Amendment Act 2009. Very important and frequently asked in judiciary examination. When the term victim is included in the Cr.P.C., answer is as per Amendment Act 2009. The term victim is included in the Cr.P.C. and definition of victim is defined in section 2 subclause WA. Keep in mind, section 2 subclause X defines the term warrant case. Section 2 subclause X defines the term warrant case, and read with section 238 to section 250 of Cr.P.C. and lastly section 2 subclause Y defines the term words and expressions used in Cr.P.C. So these are the definition sections defined in section 2 of the Cr.P.C. Very important here. 2 or 3 marks may come in the upcoming examination. So it is very important to touch or read section 2 wholly or thoroughly. So if you love this video, don't forget to like, comment and share. Thanks a lot. Have a good day.